All right, so there are a lot of people that probably haven't met Matt, and a lot of people that Matt has not met, but Matt is one of the partners at our outside counsel that handles a lot of our subrogation cases. He's out of Tennessee. We've known each other for since I've been at Blue Cross, and he's got a relationship with people that are on the team for much longer than me. But Matt's always done a fantastic job, and one of the things that we always try to talk about annually is just continuing education. And oftentimes he'll come into office and present and talk to us about different types of case law or things that are changing in the subrogation and work comp space. But unfortunately this year, due to COVID, we're going to have a virtual presentation instead. But one thing that caught our ear is we were talking to Matt at the end of 2020, and he's anticipating 2021 to be one of the biggest years for subrogation ever that he's seen at his law firm. And that got us talking more about how he can share that information with us. So without any further ado, I'll introduce Matt. And Matt, just want to beforehand thank you. We always appreciate the relationship, and thank you for presenting.
Hey, thank you, Dustin. The first thing, one thing you said about education, and that's key. So I didn't even really prepare to say that, but it is key. Knowledge is power. I've said that before at NOPLG presentations, if you've ever been to one of my presentations there. This presentation was tailor-made for Blue Cross Blue Shield of Minnesota. It is not the presentation that I'm going to be giving later this month for NOPLG. What I will do for those, I guess, who are not going to go to NOPLG virtually, I'm going to be sending that link to Dustin so he can distribute that presentation as well in Minnesota. So as we get started, the title of the presentation is 2021, the year of the ox and a big year for subrogation. I have to give credit to my law partner, Lance Oliver, for the idea of using the Chinese calendar of the ox. So, because 2021 was the year of the ox, and if you can imagine, what do you think 2020 was? It was the year of the rat. Of course it was, The sign of the rat represents the beginning of a new day. No doubt that 2020 was the beginning of new days and times. The legend has it that the rat and the ox were in a race, and the rat asked the ox if he could ride on the ox. And so the ox took the rat all the way to the finish line when the rat jumped down and beat the ox. So the main point about that is we got to get the rat off our back in 2021. The sign of the ox is known for three things: determination, strength, and great success. Those are the things that subrogation professionals need as well. We are expecting a big year for subrogation as we go through all of the details of the laws and all of the Form 5500s, ERISA, non-ERISA plans, state law plans, workers' comp. Just remember this: the most important thing is putting in 100% effort and having a great attitude in what you're doing, and it will lead to success. One of the greatest quotes, I quote this all the time to people in our law firm, is from Vince Lombardi, and he says that perfection is not attainable, but if you chase perfection, you can catch excellence. And I love that quote, and I've always used that quote in coaching and things, and even with my own kids. And as Dustin said earlier, if you've heard this before, a second ago, I apologize, but he's right. Education is the key. Knowledge is power. So as we go through this, you're welcome to email me questions that you have during the presentation, and I promise you I will respond to every one of you on your question today, and we'll get that. Or you can call me. My phone number is going to be at the end of the presentation. Of course, Dustin has it. But I want to thank you guys for allowing me to speak today. So let's get started on this slide. So what do we think? What's going on here? Why is it such a big year for subrogation? Well, last year in 2020, there's excessive overbooking of every state court in the country. So courts weren't hearing cases. Everything was put on hold. We all know this. What happened is, because of that, this year the dockets are fuller than they have ever been, and they're pushing criminal matters to the front. So In addition to that, you have the perfect storm with insurance reserves. So insurance companies saved more money last year than probably ever, and reported the highest the greatest profit in history of their company last year. So now the courts are going to have to force settlements to maintain their dockets, and the money is there. So we're already starting to see that happen in this first quarter, where the number of settlements are increasing as courts are becoming active again. So that is one thing we believe and have already seen. It's going to really increase the number of settlements, which is going to create more volume, but at the same time, and most importantly, it's going to create more opportunities to make collections for your numbers this year. Next slide. So the three things affecting settlements in 2021 and beyond. Okay, as Dustin said, overall knowledge of subrogation law and years of experience. We're going to go over that today. Maintaining efficiency and securing settlement funds before they are dispersed during this year of case overload, and having a trusted legal partner to help you with problem cases. The most important part of that in number two, before they are dispersed, is so key. As we all know, and we're going to talk about this in more detail in a second, but if you don't lock down the money, in the settlement money, before it's dispersed, if you don't secure those funds, if you don't obtain the agreements that you need with the member's attorney, that money is going to be gone. And then practically speaking, it's hard to get it back. We all know that. But there's case law now for ERISA plans that if you don't lock down those funds before they're spent on non-traceable items, it's even worse. The ERISA plan at that point does not even have a claim to bring in federal court. So the backlog of cases, coupled with the insurance reserves and things having to get going, plus the fact that the law is what it is with respect to making sure you have to lock down and trace these funds, is sort of creating this perfect storm that we all have to keep up with to make sure that the groups that we represent, that you guys represent, that you're doing work for, these self-funded ERISA groups, are happy, they're receiving the collections that they are entitled to, and that we're not missing settlement opportunities. We just think there's going to be a lot more volume with respect to settlements this year than anything. Next slide. If we do that, I love this picture of New York. Together we'll have a roaring 20s in 2021. So as you may remember, in the early 1900s, you had the Spanish flu, and America dealt with that for years. And then you had the roaring 20s, which a lot of that is why, because people could get back out, and they are getting back out, and we're seeing drivers, and so the number of files are going to pick up. There's more accidents. It's going to get back to where it used to be, but it's going to be even more volume intensive because of what I've talked about earlier. So I want to introduce myself. There's maybe many of you know me, but there's probably many that don't. I'm the managing partner of litigation operations and finance at Russell, Oliver & Stevens. We've been around for 20 years, and I've been a lawyer for 20 years in November. 17 of those years I've handled health plan subrogation. Fortunately, our firm has handled 2 ERISA cases that were ultimately heard by the U.S. Supreme Court, and I was lucky enough to get to attend oral argument at the NDC on the Sereboff case. We lost the first one and won the second one, so we're 1 for 2, but I think we won the most important one. But one thing that we get to say on the phone to these members' attorneys, which really creates dollars, is that we've litigated more ERISA subrogation cases than any firm in the entire country, which is a statement, and it's a true statement. And we've represented the best thing, and I'm not just saying this, you guys are one of my favorite clients. As far as internally, there are not many clients I have that really have it together like Blue Cross Blue Shield of Minnesota. And I love your motto, your slogan, live fearless. I love what it's about. I love that. And I've been, fortunate enough to represent you guys for over 12 years now. So we're here for you. My whole firm, we've got about 50 employees, 10 lawyers, and we're all here for you. If you have any questions, You can always email me and ask a question if you're not sure about something, and I'll help you. There's no charge for that. It's just part of the relationship that we have with your firm, with Blue Cross of Minnesota. So I'll go to the next slide. So before we get going on the meat of this, which is work comp procedures versus subrogation procedures, I kind of want to talk to the people who are switching roles, or maybe there's people there, there's subrogation professionals there that are going to be working on both subrogation and work comp that may have only worked on work comp matters before. One of the things that I like to do, and I've given this particular presentation before, is point out the similarities of workers' comp cases and subrogation cases to make it easier for people transitioning from subro to work comp or work comp to subro to understand. So we're going to talk about what's important for both, but before we do that, I want to talk about what is a workers' compensation case? How is it defined? What's the main difference in that and a subrogation case? So first, you have a member is injured on the job and files a claim against his or her employer for benefits under workers' compensation laws. Well, the main key here is fault does not matter. Wait a second. What do you mean fault doesn't matter? You mean we don't have to prove that, that the employer hurt the member? Well, no, we have to make sure that it's proven that the member got hurt during the course and scope of his job, but we don't have to establish any liability under traditional negligence theories. So fault does not matter. It's a no-fault system. As long as that employee and that member got hurt on the job and that injury was caused by that injury on the job, then it's compensable. And that's the most important thing. Well, if you look at subrogation and reimbursement and the definition of that, the difference is fault does matter. That's why the attorneys have to get involved. And as you've heard it many times, they say, well, we can't establish liability, or we're having a rough time with liability. It's a slip and fall case, and the hole was open and obvious, and this member walked in the store and didn't see a 10-foot hole. We got a kind of a slight problem there, so we have a liability problem. Well, we all know that those are issues we run into, but it's good to know that definition of fault versus no fault. Now, what's important for both work comp and just general subrogation and reimbursement? We have to know the answers to all these questions for both types of cases. What kind of plan is involved? So when I'm teaching our staff on how to work cases, the first question ever to ask is, what kind of plan do we have? And it astonishes me that some people around the country don't ask that question, or they don't know that when they're handling these cases sometimes. And so the reason it drives the entire case, because it gives you the ability to argue federal law if it's a federal plan, or if it's not a federal plan and it's one that you're dealing with state law only. Well, then whether you can apply the law of another state. Maybe they got injured in a state that's an anti-subrogation state, but your home state, Minnesota, isn't anti-subrogation, which it isn't. And so even though you have the made whole rule, it's a lot better than being in New York. And so knowing those kinds of things on the front end really allow you to prepare your arguments with the member's attorney or the defense counsel or insurance workers' comp counsel that's involved. Another question, what is the funding of the plan? Is it self-funded? Is it insured? Obviously, we have to know those things. If it's a governmental plan, that's obviously important too. The funding of the plan, if it's a self-funded ERISA plan, the great thing about it is, for people that are going from work comp to subro, is that you don't have to worry about state law for the most part. All state laws that relate to the plan under a self-funded ERISA plan are preempted by ERISA. So that means the plan document controls, which the plan documents for those groups are usually well written, and you guys have good language in your plans. Okay, well, how's my plan language? Okay, plan language, what am I talking about? Well, for work comp, you're used to the exclusion provisions. When we're dealing with work comp, we primarily are thinking about the benefits that are excluded under the health plan. Okay, let's think about, and this is something I tell plaintiffs' lawyers all the time, they're so concerned about the plan document, but you have to understand the theory behind a health plan is more of a concept rather than a document. You know, it's allowing these employees to have benefits, which we are providing, but at the same time, it creates obligations on the employee to also abide by. And so the plan language creates those obligations. So it says this, you know, we're going to talk about an exclusion provision in a second, but the exclusion provision for work comp is super important. And you want to make sure that, you know what it says. There are examples we're going to talk about in a second, but sometimes the exclusion provision doesn't have anything to do with whether it's found compensable. It just has to be something that where the member was hurt it on the job. You know, whether or not the court ultimately finds it compensable, some plan language has, been more general, or there's more specific plan language. So knowing what your plan says about exclusions for workers' compensation cases is super important. Reimbursement provision. Does the reimbursement provision, for example, have made whole and common fund language? Well, that for self-funded ERISA plans and all ERISA plans, the law is that it must have and disclaim both the made whole rule and the common fund doctrine before those equitable defenses don't exist. So if you do disclaim those two equitable defenses that they don't apply, then they don't apply according to federal law. So knowing this, but if you have a plan that doesn't go there, or maybe it adopts the made whole rule, for example, in Minnesota on non-ERISA cases, then you know what you're dealing with. Is the member still active on the health plan? Why am I asking that question? It's one of the most important things to ask, because if the member is still active on the health plan, then we know that there's a pressure point that we may be able to use to get the member's attorney to work with us when they would ordinarily not work with us. Well, why would they do that? Well, they don't want to have anything happen to their health plan coverage. And there's many plans that do state that if you don't cooperate with the plan, then the benefits of the plan can be withdrawn from going forward, or can be withdrawn from the providers paid for the accident. So that's a super question that we train all of our people to ask on the front end. And if they don't work with us, to remind the member's attorney that can be a possibility. Now, we will never take a hardline stance on. We will never say this. We will never say your benefits will definitely be affected if you don't work with us. That's not what we say. And I would not suggest saying that. I would suggest that one option that the plan has is to withdraw benefits or to offset benefits in the event that your client doesn't cooperate. And going into these things, and especially on that one, and I think this goes without saying, but obviously abide by your internal policies that your managers are giving you on those kinds of issues. But that would be my advice on that question. Another question to ask for both work comp and subro is, where did the injury occur? What adverse laws are out there, and do I need to intervene? Okay, so if the accident occurred, again, in an anti-subrogation state, New York, Pennsylvania for motor vehicle, North Carolina, Arizona, Georgia is really not anti-subro, but it's almost, it might as well be, Virginia, places like that, Missouri. We want to know those things, because we're going to know instantly, okay, I'm going to have to deal with that anti-subrogation law. I'm going to have to address it, even if I have a plan like a federal employee health plan, like Medicare Advantage, like self-funded ERISA. Even though we preempt state law, the member's lawyer is definitely going to bring that up again, and definitely going to raise that point. So we want to be ready for it. And again, if you're seeing the deal here, it's all about preparation. And that is the key. Where is the plan administered? Okay, well, these plans are administered in Minnesota, which is great. Minnesota is not an anti-subrogation state, even though its state laws do have a mandated common fund doctrine and made whole rule statutorily. We're going to talk about that in more specifics in a second, but it is not a state where it is illegal to subrogate. So when you're in New York, and accident happened there, and the attorney's arguing that the general obligations law there in New York applies, you should raise the point that, wait a second, this plan was issued and administered out of Minnesota, and Minnesota law controls if it's a non-ERISA plan. That's one example of why that question is important. When did the injury occur? Well, the point about when did the injury occur is twofold, and this is really important for folks going from work comp to subro. There's two statutes of limitation to really be mindful of. Number one, under subrogation, pure subrogation is stepping into the shoes of the covered member and suing the defendant. Okay, that's pure subrogation. And can the health plan do that? Absolutely. So we have that as something to be mindful of. Now, why do we need to do that? Because there are cases, what I call friendly fire cases, okay, where, let me give you an example. We had a case about 3 or 4 months ago where the insurance company who was involved, it was the driver's insurance company, told me that they had done a thorough investigation, and they found that there was no negligence in the case. It was a single car accident where there was the driver and the passenger were coming home late at night and were going around a curve on a country road, and a tree had fallen in the middle of the road, and they just hit the tree. So no harm, no foul. There were some medicals involved, but there was nothing going on, no funny business. And so they closed the file as there not being any negligence. So I'm sitting here representing a blue plan, had paid about, I don't know, $15,000 in medicals for the injuries. So I asked the adjuster, and I said, well, did you get the police report? And he said, no, we didn't bother with the police report because we took the statements from, our insured. Well, the insured was best friends with the passenger. And so, which we found out later. And I couldn't tell the client to close a file without having a police report. So we go out and do the research, and it was very hard to find the police report in a very rural area like where this happened, East Tennessee, if you will. If anybody's seen Deliverance, that's kind of what I'm talking about. That kind of small town. So we finally get the police report, and lo and behold, the driver was driving underage and intoxicated. And that was never revealed to the insurance company. Our member was the passenger. So the member didn't want to sue his friend and didn't want to get him in trouble. So he just let the health plan pay for everything. Well, yeah, that's great if you're him, I guess, but when we're the health plan, we want to get paid back. Well, going back to when the injury occurred, when I had received the file, it was after the statute of limitations had passed. And so I had to call back the adjuster, and I said, listen, I'm not quite going to say bad faith, but I think that's kind of what I'm thinking right now. And I think you need to reevaluate this case because I'm going to send you the police report that shows that your insured was drunk and underage. And when I told him that, he couldn't believe it. And they ended up paying, since it was after the statute of limitations, they reconsidered, but they paid about half the lien, which is, I feel like that was a win, being that there was no attorney involved. No one had ever brought a lawsuit within the statute of limitations. But that's why it's important to note that when the accident occurred, because you want to keep up with that subrogation statute of limitations. Now let's transition to reimbursement. Now, what am I talking about? What's the difference in subrogation and reimbursement? Reimbursement, we're still talking about what y'all think is general subrogation, but reimbursement is what we normally do as a health plan, which is there's the member's attorney. They are representing the member, and they sue on behalf of the member. Then they get a settlement, say $100,000, and then we ask for reimbursement from their settlement. So we don't have to worry about, in that situation, keeping up with the statute of limitations for subrogation because the case has already been filed by the attorney. But what we do have to make sure is we don't run afoul to the statutes of limitation for reimbursement under ERISA and other laws, which I can tell you, under any situation, you don't have less than a year to bring a claim for any reimbursement claim that's out there. I don't care if it's, FEBA, ERISA, Medicare Advantage, anything whatsoever. You're going to have at least a year from the time of settlement. Now, I would recommend working things out on the front end to where you never have to worry about those things. But that's so important to know, and I think that gets missed sometimes. The next bullet point: has there been any recovery yet? Well, when you get involved, you're responding to an open file as a result of a questionnaire being sent or information being received from an attorney. We'll ask that question: has there been any recovery yet? Because the problems are this. Let's say that the accident happens in January. Well, by the time the questionnaire is received back, let's say the member ignored the first questionnaire, answered the second one, and so let's say it took 3 months to settle the case because there was no question of liability. Well, that's a situation where by the time the health plan gets involved and finds out about the lien and is able to put the attorney on notice, well, the funds may be spent. So it's always great to ask at the very beginning of the case, has there been any recovery yet, not only to the member's attorney, but to any other counsel involved? Because a lot of times the member's attorneys, they're sitting there working on other files when you contact them. They may not really know. They may say no when it really was a yes, or when they've received some med pay or something like that. So lock down the facts about whether there's been a recovery. The next bullet point is, who is the member's attorney? Why is that important? Well, I love it because in doing this for this specific area of the law for 17 years, I've got to know some attorneys across the country who are good and who are really bad. As we all know, we all have our little list of attorneys that we like, and we certainly have that list of attorneys we don't like, and the ones that we feel like are not going to be honest with us. So when you go into a case, do a little recon on who the attorney is. Do they have a big practice? Do they have a ton of attorneys and staff, or is it a one-person shop? Those things are good to know, and especially with negotiation. And then, who are the insurance carriers that play? I mean, these are questions. That's an obvious one. I think everybody gets that, but those are super important questions that really need to be answered on every case and kind of at the beginning of each case. And we'll move on. If we go through this and there's specific questions, email me those. I'm okay if you guys want to, hit your button and ask the question. Take yourself off of mute and ask the question, and we can do it that way, or you can email me. Either way is fine with me. So the next slide is what specifically workers' compensation procedures. So we're going to spend a little time on this, but I want to point out, in a lot of these slides, I'm not going to read verbatim to you, but I want you to have them as reference. You can print it out and have it at your desk or things like that. But first, obtain the workers' comp claim petition and immediately give everyone involved written notice of the lien, all insurance carriers and attorneys. And next, which is super important, is obtain a written agreement that they will contact you to resolve the lien prior to resolution of the case. Most important thing, as in subrogation, those that are coming from work comp to subrogation certainly know this. They're going to try to leave you out. They're going to try to work around you. They go in the back room, so to speak, and the work comp carrier and the member's attorney will strike a deal, even though there's no finding of compensability. The court's not found compensability, and there are going to be arguments on both sides whether the claim is compensable. But they're going to settle the case, and then they're going to turn to you if you've been involved, and they're going to usually say, this claim isn't compensable for X, Y, and Z, and therefore we don't think you're owed any money. But if you, at the beginning of the case, set an expectation that you're going to be dealt with, that we are going to enforce this workers' comp lien, and you're very serious about it, then you can obtain a prior resolution, so to speak, an agreement that at least the attorney for both sides will contact you and deal with you. Most important thing here is to check on that next bubble, check state laws and timely intervene if necessary. Minnesota, if work comp, you have to intervene. California, work comp, you have to intervene. I use those two because one, you're in Minnesota, and two, California workers' comp, if you've dealt with that, is one of the hardest things I've ever seen. The fortunate thing is, and I'm going to give a little shout out to one of our senior associates, Zach Jordan, he has mastered California workers' comp. We have a success story involving Blue Cross Minnesota that some of you may know. I know Mary knows about this case for sure. Is that we were able to recover $100,000 on a $150,000 lien in California on a workers' comp case. It is highly intensive as far as the documents you have to produce, when you have to produce them, the form in which they have to be in, and there's a whole lot of things that have to happen. So if you internally have mastered that yourself, great. If you need help on those or Minnesota workers' comp cases, we can certainly help you because we've done those for years. But let us know if you need help on that. The focus here in the next bubble is on the strength of the exclusion provision. We talked about that. Does the exclusion provision hinge on a finding, okay, or does it apply even in the absence of workers' comp coverage? I've seen both. So again, know what you're dealing with on the front end. As a backup, make sure the plan's reimbursement provision is well drafted. Well, wait a second. We're talking about workers' comp, Matt. Why would I ever have to deal with the reimbursement provision? Well, I can tell you that many times under the exclusion provisions, the health plans are going to still pay. The pay and chase method is in effect. And even though we later find out that we could exclude those benefits or pull those back, maybe there's timing issues. Maybe there's client or medical provider relations that are running afoul to pulling those benefits back. So the other way to recover, for example, is if it's a self-funded ERISA plan, for example, and you have good reimbursement language, then you can tell the lawyer for the employee's workers' comp lawyer, okay, that you have that and that you can enforce your reimbursement provision even in a workers' comp case from any recovery they obtain, which is exactly what the plan says. So that is a great way to make a recovery, even if the traditional exclusion provision and working with defense counsel on workers' comp cases isn't a viable avenue. Going to the next bubble, obtain and review all settlement documents and orders. I had a case not long ago, I would say about a year and a half ago, where the member's attorney and the attorney for the carrier, they were really dodging us, and I later found out why. Well, I was able to obtain a copy of the document and the order of the court, the workers' comp judge, and it said specifically that the carrier, work comp carrier, is going to have to pay for past and future medicals related in this case, and it actually mentioned our client's lien. Well, they didn't even tell me that. So they were trying to negotiate it down, even though there was an order for them to pay the full freight. So once I found that out, I showed it to them, and then they had to pay the lien. But you have to, unfortunately, lawyers will lie on occasion, or they will not tell you the whole truth, and that's unfortunate. But they will do that. So obtain the settlement documents and orders. Especially in work comp cases, again, the parties will try to hide the ball and keep the health plan from knowing everything. So involvement is the real key here. The most time, the more you're involved, the more you set expectations early with the members' lawyers, the better. Next slide. These are just 3 examples of exclusion provisions. I'm not going to go into great detail with them. The bottom one, workers' comp, treatment of any compensable injury as defined by applicable workers' compensation law is not covered, regardless of whether or not you have filed a timely claim for workers' compensation benefits. So that's really broad because even if the employee fails to file, it's still excluded. The first one, again, an injury arising out of or in the course of any work for a wage or profit, whether or not with the company. So they're going to exclude it looks like side jobs. If this member is working a side job painting a house, or disease covered with respect to such work by any workers' compensation law. And I mentioned that one because in a second we'll talk a little bit about COVID. I'd like to, if I were sitting in front of you live, I'd ask, show of hands, how many COVID-related work comp cases do you have in your office? I don't know that. I think you may have some. In our office, we don't really have that many. I don't even know if we have any that have been assigned to us. But I know that Minnesota has a law in place, and we're going to go over that in a second, specifically, that covers COVID-related injuries in the workplace for frontline people, especially. So we'll talk about that in a second. We're going to move to the next slide. Okay, as opposed to workers' comp, if you're going from workers' comp to subrogation, here are the specific procedures for subrogation reimbursement. Number one, determine the type of plan. We talked about that in the funding. Okay, we've talked about determine the state where the accident occurred and where the member's attorney is located. It'll tell you what the member's attorney is going to argue, what they're used to. Again, where the plan was issued. That's the key to obtaining recoveries many leave behind. Give the member's attorney a written notice of the lien, obtain an agreement on the front end that they will contact you and hold the funds in their law firm's trust account until the lien is resolved. Okay, that's key. We're going to talk about why in a second. ERISA plan document request. So I want to switch gears here and talk about this. There are many situations, and I know that subrogation people have dealt with, where the synergies of the world, the zip liens, other subrogation outfits that represent members' attorneys. They come to you or they send you a letter and they want all these documents, and they want the plan document as opposed to the SPD. They want everything that's ever existed with this group, and you get it and you're like, oh man, this is terrible because I only have the 2017 SPD. That means I've got to go get the account executive involved to get to the group involved, and yada, yada, yada. So that's why on the front end, it's better to know what plan applies to your case. That's kind of one of the reasons we set that out at the very beginning, is so you don't run into these problems. Because one of the worst things you can do is on a phone call with the member's attorney is say, we're entitled to every dollar. For example, our plan language is perfect, and let's say you have the SPD in front of you and it's perfect language for subrogation and reimbursement. And then they later say, well, wait a second, you're quoting from the new document, the 2020 document, for example. We want the document for the year of the accident, which was in 2015. And then you get that document and you might have a situation where the language in that document isn't as good, or maybe the plan document, as opposed to the summary plan description, which is, some people call it the master plan document. Maybe it doesn't have any subrogation language, or maybe it doesn't mention the SPD. All they're trying to do, the most important thing about this slide, is to understand that all they're trying to do here normally is figure out one of two things. Number one, they want to confirm that they really owe you money, okay? And then number two, they're trying to poke holes and make any argument they can to get a reduction. That's really it. And so under ERISA, this is what they're entitled to. So I've given it to you right there. The latest summary plan description, including any interim summary of material modifications. That's what SMM stands for. The 5500 forms and those other documents there. Now, what's not included there, and there's case law on both sides, but you may want to, you may ask this question. Sometimes they ask, is the ASO, the Administrative Services, the ASA, the Administrative Services Agreement, is that an ERISA document or not? Do we have to provide that document? The answer is no, okay? There's case law that supports the answer of being no. There is case law that goes on the other side, but you can withhold that. Now, one thing I will say practically speaking is what you're really trying to not provide them in my experience, is all the pricing information that's in there between the plan and Blue Cross. We certainly don't want that around the country and being, disseminated. What you can do, as long as management approves this, is if in those situations where maybe the 5500 form is not clear or there are other questions, you can always provide the ASA redacted copies of the ASA, like for example the cover page, or maybe just that cover page where in the funding page that shows the relationship between the group and Blue Cross is one of just an administrator. Okay, Blue Cross being the claims administrator rather than the insurer. So now let's talk about that next paragraph where it says determine the date when the attorney requested the ERISA documents in writing and see if any documents were sent in response to his letter within 30 days. Okay, so the problem is when they send it, sometimes the group or Blue Cross, you might not respond within 30 days. You have a lot of files. I get it. Then they're going to say, well, wait a second, because you didn't respond in 3 months, we want that much in penalties. Before you agree on any penalties, I think you need to remember two things. Number one, last year was a COVID era. We had a pandemic, and I think that there's a plausible argument to a judge that because no one was in the office, that you're going to get some that those rules are going to be relaxed a little bit. Now, I'm not saying every judge in the country is going to agree with that, but I think that's a practical issue you can certainly talk to an attorney about. Number two, and this is the most important one, if the attorney did not submit that request for documents to the plan administrator, which is not Blue Cross Minnesota normally, then they're not entitled to any penalties because you can only get penalties from the plan administrator upon them sending the proper 104B4 document request to them. So that's something to always remember. And then, if the member's attorney is not satisfied with the plan documents you provided, then you need to walk them through why they need those documents. What do I mean by that? Well, the reason they're asking for these documents, and this is the first thing I said, was they want to make sure they owe you money. So if they're confused, maybe they're a plaintiff's lawyer, but they really have never dealt with ERISA, maybe they're new, walk them through why it is a self-funded ERISA plan. Okay, what is an ERISA plan? Well, it's any private plan that's not a school or a plan or a church plan or a government plan or a plan that wasn't sponsored by the employer like AFLAC, okay? But any private employer group is an ERISA plan. Our law firm is an ERISA plan, for example. It may be an insured ERISA plan, but it's still an ERISA plan. So walk them through those things and then, ask them, show them in the plan document, for example, the SPD, where it says the funding is self-funded, where it says it's an ERISA plan. Show them the 5500. This is something important. Make sure you have the right 5500. You're going to have in the 5500 form, which I think is the next slide, is an EIN number, an employer identification number, and it's always best to show that how that EIN number in a 5500 form and the plan documents line up. So that gives the member's attorney less concern for committing malpractice. Because as we all know, there are vendors around the country, and I had a guy tell me yesterday, he said one bad apple, messes up the entire bunch. And so what's going on here is there are vendors out there telling plaintiffs' lawyers that things are self-funded and ERISA covered when they're not. And so they're trying to protect themselves from their members suing them for malpractice. Let's talk about the 5500 form for a second. So when we walk someone through that to establish that it's self-funded and ERISA covered, we look at paragraph 9A for the funding. A lot of times the insurance box and the trust box or general assets box will be checked. Well, you're asking, and they're going to ask, well, wait a second, if there's insurance on this plan, well, then it can't be fully self-funded, okay? And that's not true with respect to the health plan. So what you're usually looking at is that company's health and welfare benefits plan 5500. Well, so what I mean by that is it's not just the health plan that's being discussed in this 5500 form. It's the disability, it's the life insurance, it's the accidental death and dismemberment insurance, it's many other things, the vision plan. So you have to understand that they're not going to do a 5500 form normally for every benefit provided. So they're going to lump it into one, and then they're going to check all that apply in paragraph 9A. Well, obviously, most companies don't self-fund their disability coverage, okay, or their life insurance. And so that part of the plan and that benefit in the plan will be insured, whereas the health plan coverage will be self-funded. And the great thing to know is even in that situation, preemption is not affected. So if the health plan is self-funded, but other components of the plan are insured, it doesn't change the preemption effect for an ERISA-covered plan, for a self-funded ERISA-covered plan. And neither does the existence of stop loss. So you'll have arguments sometimes from members' attorneys that because there's a stop loss policy on the plan. Well, what is stop loss? I'm sure everyone knows, but there might be someone that isn't clear on that. And so stop loss is basically, let's say me and you own a company, and we're running our company, and we self-fund our health plan for our employees. We want to make sure that if one of our employees has a catastrophic loss where our medicals are, say, above $100,000 in paid claims, that we have an insurance policy in effect that will self-fund everything up to $100,000, and anything after that for this particular accident will be covered by the stop loss policy. Well, many lawyers try to say that existence of that type of insurance plan prevents the health plan from arguing preemption under ERISA. And there's many cases that hold that the existence of stop loss insurance has no effect on the preemption power of ERISA. So that's simply not true. So the importance of preserving funds. A minute ago we talked about locking down the funds and why that's important. Here's the case, Montanil, and I know virtually everyone knows about this case, so this isn't anything new, but I want you to know it's out there, and I wanted to give you some background in the case to kind of explain how that case even got there. And the main gist of the reason why that Montanil was decided the way it was is because the law never changed. Since the Knudsen case that we handled, you had to trace funds, you had to lock down the funds because the ERISA plan only has an equitable claim, okay? And when I'm sitting there in front of, at the Sereboff oral argument, Justice Breyer took his ring off and kind of explained equity. And he said, if I give the ring to this guy and the ring goes to the other guy next to him, and he gives it to this woman down the street, and then that person gives it to someone, that I can't sue the person that first had the ring for the value of the ring. I have to sue the person who is holding the ring currently for the ring itself. And that's what equity is. And so the same situation we have here is the settlement funds that are obtained in the personal injury accident is the ring in that example, okay? So we have to sue for that pot of money. Now, if that pot of money is in possession of a bank, there's case law on special needs trusts. Wherever that money is, as long as you can trace and find that money, then the ERISA plan does have a claim under the plan terms. But this is a case that says if you cannot do that, and the money's been spent on what the court said, non-traceable items such as food, clothing, things like that, if the guy or girl went down to the casino and put it all on red and lost, then the ERISA plan has no claim. Certainly if they put it into property, they put it in their house, paid down their house note, that's possible you could maybe secure it that way. But the most important thing is getting there on the front end and making sure that the settlement of the lien happens before disbursement of the funds. After that happens, it's a very tenuous situation, as you all know. I gave you 6 approaches to protect the funds. I'm not going to read them word for word, but the most important thing is to just basically on the front end get that agreement from the outside counsel that they will contact you and hold the funds in their trust account in the event there's a settlement until that the Blue Cross's lien is resolved, okay? Let's move on to Minnesota state subrogation laws. So we have 62A095. We all know this. You have made whole and common fund. And the made whole rule basically is that the health plan, every provision of a health plan in Minnesota for a non-ERISA plan, it must state that the right of subrogation or reimbursement doesn't arise until after the covered person has received a full recovery. Well, that's a problem, because I'm 46 years old. I'll be 47 on April 8th, and I've never seen, according to a member's attorney, a made whole plaintiff. It's sort of like a Sasquatch. They're often talked about but rarely seen. I've never seen one, according to the member's attorney. So what do you have to do in those situations? Well, if there is no, I like to do this. If there is no jury verdict or finding by court on what the damages were, then, and let's say that the numbers are, first of all, you do have prima facie not made whole. Let's say a low policy limit and your lien is higher than the policy limit. Obviously, they're not made whole. But if you have a situation where maybe there's a $100,000 recovery and a $20,000 lien, then you got to kind of look at what the value of the case is. I like to use that argument, value of the case, because number one, it works, even though if you had to litigate it, they may not look at it that way, but it does create doubt in the mind of the attorneys. And doubt equals dollars, I've always said. So look at what other courts have held the value of a similar case in Minnesota, and that's a good way to poke holes in the argument of made whole. Common fund, as we all know, we have to deal with that, in situations for non-ERISA, non-federally controlled plans. Another exception to these two rules in Minnesota are self-funded governmental plans under the Hosh case. So if you have a self-funded governmental plan, a Medicaid plan, a self-funded ERISA plan, FEBA, or Medicare Advantage, you don't have to worry about made whole or common fund as long as the terms of the plan are good. Now, with Medicare Advantage and Medicaid, there will be a reduction for attorney fees. Okay, that's built in the statutes and the Code of Federal Regulations governing Medicare Advantage, for example, and your own state law governing Medicaid. If there are questions about that, we can talk about that. Email me. And one thing, I'm going to use this opportunity to talk about this. So that next little paragraph that says statute is found in the insurance code and will likely avoid ERISA preemption under the savings clause of ERISA. Okay. Now, I could talk about 2 hours on just this savings clause of ERISA, but the one thing I want you to know, especially for people who are transitioning into subro, if you have an insured ERISA plan, okay, and you're dealing with a lawyer in a place where the accident occurred is in an anti-subrogation state, you need to figure out if that law that makes that state an anti-subrogation state, is that a law of insurance or not? And you're asking me, well, what does that even mean, Matt? So there are only a couple of places around the country where anti-subrogation states and the laws making those states anti-subrogation have been analyzed by the courts to determine whether that particular law is a law of insurance. Well, why is that important? Because if you have an insured ERISA plan, then you still preempt all state laws, okay, unless those state laws are laws of insurance. And in that situation, that law is saved from ERISA preemption. So the Levine case, and I would write that down here, Levine out of the Third Circuit, is the poster child for being able to overcome the bad anti-subrogation law of a state. And I'll give you a brief overview of why that's important. New Jersey is an anti-subrogation state because there's a case that says so called Pereira versus Rediger. Well, the insured ERISA plans in that state were tired of taking it on the chin, and so they said, okay, we're going to tee this up and find out if Pereira versus Rediger is a law of insurance or not. Because if it's not a law of insurance under, the strict guidelines and the policies that are in there, then we can still preempt the state law and start recovering reimbursement money from these settlements. Well, the Third Circuit Court of Appeals agreed and found that the New Jersey law, the New Jersey anti-subrogation law, Pereira versus Rediger, was not a law of insurance. So it opened up the entire state of New Jersey for insured ERISA plans. I take that argument around the country, okay, when I'm dealing with other anti-subrogation states. Now, New York is not one of those. I can tell you New York's been addressed. You're not going to have that luck with insured ERISA plans in New York. You're done with that unless you can argue that your own state's laws apply, okay? But there are states, a couple of states, that have dealt with it and have found that their laws are laws of insurance. But there are many that have not done that. So that argument, for the most part, is wide open. Tennessee has a made-whole rule, for example, that is also a case law. So any kind of made-whole rule or anti-subrogation law that's a case and not in the insurance code or statute, that is something to pay attention to and to be able to argue that even though we have an insured plan, I would rather deal with Minnesota's made-whole rule than Virginia's anti-subrogation statute or law, okay? Or, for example, the best place to argue that is, New Jersey, okay? But there are other places other than New Jersey that you can make that argument. But that's something to remember. Moving on, and we're not going to go into great detail because you guys do a good job, as I understand, on intervening in Minnesota workers' compensation cases. But I've kind of put a few slides in there about who can intervene, when you must intervene, the date, the time frames. And so again, we have been handling Minnesota, workers' comp cases since I started the firms, almost 17 years ago. So if you do need help with those, we can certainly help you. And we'll move to so Minnesota state workers' compensation laws relating to COVID-19. So as you probably know, the Minnesota legislature passed a bill providing that certain employees who contract COVID are presumed to have an occupational disease covered by the workers' comp laws. Those are basically the frontline people, healthcare workers, firefighters, people like that. The statutory presumption is effective for for employees who are contract COVID between April 8th of last year and May 1 of this year. So there are workers' comp cases that will come out of this. In fact, let me skip to the next slide. 36% of the workers' compensation claims that were filed in 2020 in Minnesota were COVID related. And so skipping back, these are the ways that COVID-related claims can be compensable under 3 statutory provisions in Minnesota. There's that presumption we talked about, personal injury, which is an employee who has contracted COVID but is not entitled to the presumption, and they have the burden of proving how that or illness arose out of the course and scope of their employment. Or occupational disease, basically if the presumption doesn't apply, they can go under this particular statute. So there's a couple of ways to do that. I would treat those, if you're seeing workers' comp, subro cases, workers' comp cases, that we paid claims for, I would treat those as workers' comp cases, because if they're paying them, if they're compensable and the work comp carrier is paying those, then I don't see any reason why the exclusion provision would not apply in that case. Because the member is essentially being, paid twice. And so it would be an exclusion if it was found compensable. I can deal with questions on that if you want to send me those. Let's talk about a little bit about Medicaid in Minnesota. So I've given you a lot of information here on PMAP. which is Minnesota's Medicaid program. There's a lot of information here. I'm not going to read it word for word again, but one thing I want to point out is the most important thing about Medicaid in any state. We do a lot of Medicaid work for Blue Cross Blue Shield of Tennessee. They call it TennCare. And there's a formula for, and most states have formulas for what the reductions are going to be for the member, when we can be paid, when can we receive the recoveries. But all of it hinges on one thing, and it's in that note at the bottom. The Alborn decision, which is a U.S. Supreme Court case, held that the medical expenses have to be in the case before the Medicaid plan can recover, okay? And you have that in your own state law under a case. Let me make sure I wanted to point it out to you. Martin versus Hoff. Martin X. Rel. Hoff versus City of Rochester is the Minnesota case that says that. Okay, so you have to have medical expenses in the case to recover. But Minnesota's provided three separate statutes so you're well protected for Medicaid recoveries here. And you may know all of these things. If this is an old hat for you, I'm sorry, but I wanted to at least go into that a little bit. So with the statute here, 256B056, it's an assignment. So when the Medicaid recipient receives the benefits, okay, they assign to the state the claim to recover the medical expenses, and that claim and the state becomes the sole owner of that claim. So that is big time protection. You don't have to intervene. I want to make this point clear. There's this Damgard case versus McKinnon. It's from 2016, and it kind of reiterates the fact that you don't have to intervene into the state case, the underlying case, to enforce the Medicaid lien, but the most important thing is to still be involved. So be involved, be present. This is one we certainly could help you with if you need it, about, attending by phone the mediations, okay? Anytime there's any discussion of settling the case, setting expectations early, nothing different than really what we've talked about for protecting other plan liens. But you don't have to intervene. You don't have to, bring your own lawsuit, so to speak. You don't have to do any of that, but you do have to remain and take part in settlement negotiations, because otherwise what you have to protect is the fact that the medical expenses get in the case. So the one thing that we do for Blue Cross Tennessee, for example, is we sometimes, there are affidavits that are drafted. We provide that. We work with these members' attorneys to make sure that the medical expenses are in the case. There are cases where, the expert witnesses are not lining up the medicals, and those are problems in every case. Subrogation, workers' comp, Medicaid cases. You're always going to have issues with relatedness sometimes, but to the extent that they are related, it is vital to make sure that these medicals are addressed in the lawsuit. The way that I've handled these in the past with really difficult attorneys is entering into an agreement up front, maybe a three-way split agreement up to the formula, something like that. And I've had them do that and sign it, have their client sign it, and that way, let's say halfway through the case, that the medicals are excluded by the judge, something like that, right? Well, you already have the agreement in place that's going to control. And I actually had that happen in a case, and if I hadn't had that agreement in place, the member's attorney would have quit talking to me. They would have never worked with us. So I can't iterate enough that the front end work and the setting those expectations is the most important thing. Let's move on. There's another statute that allows you to seek the subrogation back for Medicaid. That's 256B042. Again, it's still limited to medicals. And to rely on this statute, the Medicaid plan must comply with the perfection procedures. So I've listed those for you here on how to perfect the liens. And you can do this, and it certainly will help with making sure the medicals are included. There's timeliness. You have to do it under certain amounts of time. I'm going to skip to the next slide about notice provisions. The great thing about here is there's a lot of notice provisions that the member and the Medicaid recipient has to provide notice to the Medicaid agency. So they have to do it before the claim's filed, during settlement negotiations, and once the claim is concluded. The most important thing to remember here is if you look at the timeliness, the lien to perfect it must be filed 1 year from the date notice is first received, even if notice is untimely, or 1 year from the date medical bills are first paid, whichever is later. So again, there's that protection that the state's providing you and giving you extra time because, you don't have a crystal ball, you don't have osmosis, sometimes you don't know that these claims are out there. And if the member doesn't do a good job or their attorney doesn't do a good job with notifying Blue Cross about these liens, then you have these protections in place. So if notice isn't provided, then you have 1 year from the date the state agency learns of the lack of notice. Enforcement of the lien. So let's say that you're going to bring an action to enforce that lien. Well, you can do that 1 year of the date of the notice is received, or 1 year from the date the recipient's cause of action is concluded. So once the settlement's taken place, once there's a judgment, jury verdict, or otherwise, you have 1 year from that date to bring that action or to argue and threaten that you will bring an action. And that's the key point there. We're not litigating a bunch of cases right now because we've done so much litigation in the past. And I guarantee you that the management at Blue Cross at any state would probably prefer to stay out of litigation, but still make good recoveries. So the argument that you can bring in the lawsuit and you're timely, going back to what your knowledge of the law, knowledge is power, education is key, is what Dustin was saying, comes back to fruition here when you're talking about enforcing these liens. I'm not going to go in and say, hey, I filed a lawsuit to enforce this Medicaid lien because you didn't give us notice, and we know that we're 6 months from the settlement. And guess what? The last sentence there says that the agency can commence the action against any or all of the parties which have either paid or received the payments. So that, insurance companies or members' attorneys or members, you can, those, all of the people can be involved and discussed and action can be brought against, according to what this is saying. So there's a lot of strength here. Going to what is Medicaid entitled to? So, you always ask this question, what's the formula? What's the Medicaid formula? So the formula is this. It's really good. It does protect the employee or the member, but it is good. So only part of the settlement, judgment, award, or verdict that is for medicals is obtainable. That's the Martin case we've talked about. Then the attorneys get their money. Okay, of course they do, right? The attorneys get their fees and costs are first deducted from the settlement. Then the full amount of the medical assistance paid by PMAP is deducted. Okay, now that's the full amount. So it's deducted after the attorney fees, but what has to happen is the Medicaid recipient has to get at least 1/3 of the net recovery after the attorney fees and costs. So if it's $100,000, and let's say the attorney charges 40%, so we're down to $60,000, the Medicaid recipient has to get at least, $18,000, I'm sorry, that's 30%. So 33 1/3% of $60,000, okay? So they have to get that, and then the Medicaid can get the rest. So that's the way that the statute operates with respect to the Medicaid formula, okay? So I think we're about 11:45 or almost 11:45. We were going to go till about noon. Dustin, I'm okay if anybody wants to click off and ask questions. I wanted to leave a little time, which we were fortunate to do that.
Yeah, that's perfect. And Matt, thank you so much. We did have a couple of questions that were coming into the chat
Jeff,
while you were talking.
Please.
Can you hear me there, Matt?
Yes, sir.
Yeah, we had a couple of questions that came into the chat, and I will rely on those people to kind of unmute themselves. And I think Mary was first. And then, of course, if we have time, Carrie would like you to tell the infamous New York story.
Oh, I would love to.
Yeah,
I should have done that. Thanks for reminding me.
Let's get to the questions first. We've got Mary and then Yolanda.
Okay.
Okay, so I had two questions, Matt. It's Mary. First, this is so foreign to me to see attorneys basically lying. It's just not something we really encounter in Minnesota, quite frankly, and we're running across it on the out-of-state stuff.
Right.
They're officers of the court. I mean, aren't they subject to sanctions or actions by the state board for intentionally misrepresenting the facts of the case to an involved party?
Yeah, there's no question about that. And to illustrate your point, Mary, Judge Posner, the Seventh Circuit, counseled is a mild word, but basically, in an opinion, suggested that Georgia's district attorney and the state bar of Georgia get involved because this Georgia attorney lied and said that he had only recovered $50,000 in a settlement, but when the secretary sent a copy of the check to the lien carrier to show it was only 50 grand, accidentally sent a $500,000 UIM policy check that they had also received. And when that happened, he got reported. So to answer your question, absolutely. Now, it's all variances of gray. They can always say on certain situations, oh, I forgot about that, or, sometimes they make up situations that or blame somebody in the office for not fully informing them. There's ways to get around that, but I'll always go back to this, Mary, is that if you have the documents that tell the story, then you have everything. And so I always say, always have a document that if you can get it, that gives the basis of what you're relying upon for the truth.
Okay. And then, in Minnesota, when we intervene, the court's aware of our involvement. So the judges won't sign the stip unless our rights are recognized, right? Or at least we sign off or we're addressed in the stip somewhere.
That's right.
Since we don't intervene out of state, is there a way for us to insinuate ourselves onto that state's Dolly site so they're aware of our involvement?
In some states you can. I mean, California is one of them, of course. The way we handle it in Tennessee, we really don't get the courts involved, but what we do is we make sure that both defense workers' comp counsel and the members' lawyers are well aware, and that we get agreements from both of them that they'll deal with us before. Many of them will still stick us in. We won't be like a named party, of course, but if there usually is a stip and order we'll have to agree to and sign, even though so in that situation, yeah. So I think you can get that done, but you have to do it on the front end, and you have to really get the agreements. And not all lawyers will agree to do that, but it's all in how those conversations are taking place and how those expectations are set. I hope that helps, but that's how we do it. But for the states that we don't have to intervene in, we usually don't, because we have good luck with getting those upfront agreements.
Okay. And then finally, the agreement, can it be in an email form or does it have to be in letter form?
That's a great question. I'm okay with getting an agreement to contact and hold funds in an email, okay? Because you got to remember, what you're trying to do is create, even if he says or she says, oh, well, you only have an email, that's not in writing, it's not enforceable, it's still something that person's got to think about, because you may go try to enforce it in court and then they may have egg on their face. So, and the other reason, practically speaking, an email is better in some respects is because they're busy. So you frame it up, the letters, to say, hey, please send me a response to my email and state, quote unquote, agreed to, so that you agree to contact me and hold the funds. Well, they're busy and they're kind of going through emails. Oh, okay, I'm okay with that. Agreed. It's real simple for them to just type agreed and send it back to you. Well, then you've got them. And I'll tell you a quick story. Nevada. The only reason this attorney paid us, and I actually know the guy well, but they dispersed the money and they did not deal with our lien. And this was a pretty sizable lien. I think it was like $100,000 and they got like $300,000. So, they kind of owed the money. Well, the associate did not see our letter in the file, made a mistake. They agreed it was a mistake. But because we had an email and because they had agreed to contact us and hold the funds, he paid us our lien back out of his own pocket. So it was like $100,000. And he told me he was going to take it out of her pay, unfortunately, over the years. But but the point is, if you don't protect the plan's lien, in writing, so have something. Now, that's a good question, because the other way, at the front end on those Medicaid cases, I actually have the member's lawyer and the actual members sign off on those in writing, like sign a document. That way, if they switch attorneys or if something happens and there's just if I have to use it before the judge, which it's going to happen more often in those cases because the medical expenses are so volatile sometimes in those cases, that I can at least show that this was agreed upon in writing. They signed it, they thought about it, and the attorney for the member educated them before signing it. So I think anytime you can get that, that's better, but an email is okay for an agreement to contact and hold funds.
So since we're dealing with the paralegals a lot on those emails, does the firm have to basically indemnify them for what they state?
That's a great question too, and I've heard it both ways. I mean, if all you can get is the paralegal to say that, I would get it, but I would also ask the paralegals as a training point to your staff to ask the paralegals to copy the handling member's attorney on that email. That way that attorney can't say he didn't know about it.
Perfect. Thank you so much.
Yep, no problem.
And thanks for that recovery in California. That was great.
Oh, thank you. Thanks for the opportunity.
I second that one. Thank you. So then the next question we had was from Yolanda. Yolanda, can you hear me?
Yep.
All right.
Yolanda, How are you doing?
I'm doing good.
We've talked on the phone a few times.
Yep. I'm usually the one that sends you all the California cases.
That's right.
So I do have a question on the 5500. I've actually just recently sent a 5500 to an attorney, but looking through it, it doesn't have Blue Cross of Minnesota listed. It has several different insurance carriers. Does that even matter that we're not there?
Okay, so when you're looking at the 5500 form, are you looking at the Schedule A?
Yes.
Okay. The reason Minnesota is not mentioned in there, and I meant to mention this. I apologize. I'm glad you raised that point. That is a great way to show that. Is your plan a self-funded ERISA plan?
Yes, it is.
Okay, that's okay. The reason it's not mentioned in the Schedule A, and this is what I would tell the attorney, is because Minnesota is not insuring anything. The only thing in the Schedule A should be the insurance providers. So Minnesota should never be in a Schedule A on a self-funded ERISA plan. Where Minnesota will be listed, if there's a Schedule C, not every plan has one, but it should have one, is the Schedule C shows all the service providers. And the service providers would include claims administrators for self-funded ERISA plans, such as Blue Cross Minnesota.
Okay.
And if you walk them through that, by exclusion, the attorney should see that, okay, well, that makes sense. Therefore, there is no insurance that Blue Cross is providing.
Okay, because I'm looking at where would the Schedule C be then?
After the Schedule A. So the way it's just right after the Schedule A. And again, you may be looking at one that doesn't have a Schedule C, unfortunately. But
Okay.
if paragraph 9A has general assets or trust checked and Blue Cross Minnesota is not mentioned in the Schedule A, then the medical plan self-funded and ERISA covered. Yeah, that's a great point, and it's one that I meant to raise. So good job catching me on that one.
No, thanks. I've been having to deal with this one this week, and I'm just like, okay, I know he's like fighting me on it. I'm like, no, I know we're right.
Yeah,
So we just keep going back.
Stick to your guns. I mean, I can tell you that they're going to give up before you will.
Okay, that sounds great.
Lawyers are lazy.
Thanks so much.
This is a true story. It's probably, I'll never have another experience like this, hopefully, but probably in my whole legal career. So I plan on practicing until, I'm well in my 70s because I love doing it. But a few years ago, we had a case where Blue Cross Minnesota was involved in a case where there was a Manhattan attorney who kept telling me that he went to Yale Law School. He was super proud of it. And he asked me where I went to law school, and I said, well, I went to the University of Memphis, which is a good law school here in Tennessee. And he said, well, son, we don't do subrogation like that here in New York, and you're going to have to come up here and get your money if you want it. And this was a self-funded ERISA plan, and I kept telling him that, and I kept begging him to just please listen to me because I can show you the law if you'll read the cases. You'll read the plan, you'll see for yourself that I'm right, but maybe we can work something out if you get a low recovery. No, we're not going to do it. I'm not going to read anything you send, and that's the way it's going to be. So long story short, he would not tell me when the case settled, so I had to get an agreement from defense counsel to make sure we monitor the case. So we get that agreement. Lo and behold, the case settles. We bring a lawsuit. I'm fast forwarding through a bunch of the lawsuit filed in Minnesota, which you can do, and we served it on the member's attorney, Mr. Yale Law School. No offense to anybody that went to Yale. I love Yale. But we served it on him and his client, who had no knowledge of any discussion I ever had with this attorney, unfortunately. So you can imagine sitting there having your cup of coffee in the morning and getting served with a federal lawsuit in Minnesota about a lien you didn't pay. And the lien was pretty high. It was, I don't remember exactly, but I want to say it was, it could have been six figures as I may remember. So I got to go back and look at it. Well, the attorney said, so I filed this motion for a temporary restraining order to lock down the money in his trust account or in the member's checking account. That's granted. I also filed for a preliminary injunction, and we get that granted too. So literally this attorney writes this federal judge a letter and says, I think you and Mr. Stevens are in cahoots. I'm accusing you of judicial misconduct and Mr. Stevens of ethical misconduct because you're just granting every motion he files. And I'm not even involved, So the judge writes back and says, you need to basically learn ERISA law. You need to get local counsel because you're a defendant. And if your client doesn't pay the money into the court that I've ordered, I'm going to send a U.S. Marshal to New York, pick her up, and bring her back to Minnesota to explain to me why you didn't do that, why she didn't do that. So you can imagine what he's thinking at this point. And so he writes back in the letter and this is all on Pacer. This is all, public record. And he writes back and he says, I see that I've upset Your Honor. I've upset you, Your Honor. To make amends, my sister was once married on a small lake in Minnesota, the name of which I forget. And I'm just cackling. I'm showing everybody in the office these letters. We cannot believe this guy. He is out there, like in space somewhere. And so he says, I know that I'm not going to come to the hearing because I know as soon as I get off the plane, you're going to arrest me. And so long story short, the court, in its wisdom, has a scheduled conference call with the attorney for the member, Mr. Yale, his client, the member, this poor member who was led down the primrose path, me and the judge. When we got on the phone, all you heard was the member yelling at her lawyer, like screaming, like she'd never known anything about any of this. So we finally got her calmed down and ultimately got the lien paid. But I've never since had been accused of being in cahoots with a federal judge I had never met before. But that was a funny story. So, but it's one that it very rarely happens. I mean, a U.S. Marshal coming to your house and across state lines and picking you up on a subro case, that would have been terrible, right? But thank you all so much for allowing me to speak today. I think if you need help on any cases, we're here for you, and we can get them done immediately. So that's all I have, and I appreciate it very much.
Thank you, Matt, and thank you everyone for attending. We'll talk to you soon.
Take care.